Hello, 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 and welcome to the Hildebrand Law Firm. Topic for today, I am attorney Matt Kaplan, and I am joined by my very esteemed colleague, attorney Pierce Mobley. If you haven't noticed, attorney Pierce Mobley is on the younger side. He is 17 going on 18. No, attorney Pierce Mobley is of age. He is a somewhat recent graduate of the University of Wisconsin at Madison. He is now completing about your first year in the legal practice, right, Pierce?
Correct. That's correct.
Very exciting. And so you may think, well, he's only been here for a year. What does he have to talk about? Quite the contrary. Him and I have very interesting, very excellent, in-depth conversations. One of the things that attorney Pierce Mobley has gotten into in his time here with Hildebrand Law Firm is the world of collections. So, Pierce, tell me about collections and what you've done so far with the firm.
Well, first thing I'll say about collections is it's a place you don't want to find yourself. So if you have outstanding bills, I would recommend paying them. Other than that, collections is a very interesting sort of part of the legal profession. A lot of the times it takes place in small claims court, which has its own completely separate set of rules that normal court does. So a lot of times plaintiffs, or the people bringing complaints in small claims court, won't even use attorneys. You can go in there and file the thing yourself, and a lot of times the commissioners will be very receptive to you trying to handle your small claims issues. Think like Judge Judy. Right?
Yeah,
right, Matt?
Yeah, I would say so. I'd say a Judge Judy is probably, most people's foray into the world of pro se litigation. Pro se, of course, being I did not hire an attorney. I don't know why we needed to make up a word with two Latin words to call it someone just didn't want to pay us and wanted to do it on their own. But I digress. So, Pierce, one of the things I wanted to talk about is what sort of things in the law does the state of Wisconsin allow people who have been debted against, so creditors is what the law calls it. What sorts of things do people have in order to try to get their money back? And the reason that I want to talk about this video is not because this is something we like doing. Quite the contrary, Pierce absolutely hates doing this. But we wanted to talk about, for regular people, if you were to owe any money to someone, here are some things that they could do to you. There's some things that you could look out for. So, can you give me an example of some collections efforts that creditors can make, perhaps after a judgment is entered against them?
Yeah, so after a judgment is entered, this is the post-judgment phase now. There's several different avenues that a creditor can take. First of which is they can order or receive a court order to have the debtor show up for a supplemental examination. And as part of that supplemental examination, the debtor will have to provide their financial information, or really any information that the creditor is requesting to the creditor. So the creditor will kind of get to understand what the debtor has and what sort of assets they have that can be taken to pay off the debt. Now, a lot of people will not show up for these supplemental examinations, and if a debtor fails to show up for one of these examinations, the creditor can then pursue an order for contempt against the debtor for failing to show up. And that can lead to you being arrested if you are the debtor. And
what?
I know.
You can be arrested?
You can be arrested.
Oh boy.
For defying a court order. Now, typically creditors won't go down this path. It's really not worth the paper to get the debtor arrested, because a debtor in jail can't pay their debts.
Fair.
Mm-hmm.
Fair. So, okay, so there's a supplemental examination where someone figures out a whole bunch of information about you. What kind of information is a creditor trying to figure out at a supplemental examination?
So we're trying to figure out assets and where the debtor's money is. So bank accounts, any real property, do they have any cars or other, collections of valuable, sports memorabilia or anything of that nature. Where do they work? Because
why is that relevant?
The other thing that the creditor can pursue is a garnishment. one garnishment type is a earnings garnishment, where the creditor will serve paperwork on the debtor's employer, and part of the check that, the employment check for the wage of the debtor will be siphoned off and given to the creditor in order to pay off that debt.
Oh my gosh. So if I owe someone money, they figure out where I work, they can contact my employer, send them all the necessary documents, and then instead of me getting my entire check, a portion of it comes out and goes to the creditor. How much?
I don't have the exact number off the top of my head, but it's something around 20%, I believe.
Yeah, that sounds about right. Yeah, 20 to 25%, depending on what's going on. Now, what's really interesting about that is that, of course, for a lot of people are living paycheck to paycheck, and so it's really not a nice thing. But when you get your check and you realize 20% of it's gone, and so what are do you know? I guess, Piers, have you done this enough that what are some defenses where if you're you may be getting a garnishment? What are some things that maybe you can say that will make it so that there is no garnishment? Do you know any of those defenses? Okay, cool. So let me educate you what those defenses are. So one thing that I tell clients all the time is if you're on any form of needs-based public assistance, they're not going to garnish your wages. And what are those? Food stamps, Medicaid, things like that. Any housing assistance, any heat assistance, things like that. So main reason is that the government is already paying for you for certain things. They're not going to let it go in your pocket and then write out to a private person. So situations like that. Also in Wisconsin, if you're already being garnished, what happens to our garnishment?
I believe it takes a second step, it's second in line.
You're right.
And so the first garnishment would need to be, or the first creditor would need to be paid off before the second creditor could then start the garnishment.
Right, and one issue that you could see is, what if someone owes the Wisconsin Department of Revenue money? What if someone owes money for child support? Those always take priority. And so an issue that you might come up to is, okay, we can garnish this person, great, but they owe 50 grand in child support. No shot we're ever getting our debt paid. And so garnishments are a big thing that you can do. You talk about earnings garnishments. Tell me about non-earnings garnishments. What are those?
So a non-earnings garnishment is, instead of the creditor serving the garnishment onto the debtor's employer, they could set it and serve it onto the debtor's bank. And yeah, it's not what you want. And so, I think a lot of creditors prefer this approach for a couple of reasons. One, if the debtor has a bunch of money sitting in a bank account, they can get it all at one time as opposed to getting a bunch of smaller incremental payments from the earnings garnishment. Also, if the bank somehow messes up the response to the garnishment served upon them by the creditor, the bank is now responsible for paying that.
Gosh.
So the debtor's off the hook, and the debtor's bank, is now responsible for paying that debt.
Oh my gosh. That's called a garnishee hold liable. What an interesting area of the law. And the same thing applies for employers too. So if employers don't respond to an earnings garnishment, you could hold the employer liable for their employees' debt. Isn't that something?
Yep. So
isn't that something?
Employers out there, make sure if you ever receive one of these garnishment,
answer them. Answer them. Give the law firm a call or the collections firm a call who sent this to you and make sure it's legit, but answer them and make sure you do it. And so the reason we're bringing all this up is because it can happen to people. People can, get involved in lawsuits in which they owe other people money. It just happens, and it happens to really good people. Early in my career when I was doing collections, I was suing a lot of less than fortunate folks, but I was also involved with people who did have means, who just didn't want to pay their bills. And so just keep that in mind, where if you see yourself in a situation like this, these are some things that can happen. In the next video, we'll talk about some things that you could potentially do to make it so that this stuff doesn't happen to you. Or maybe if it does happen, you kind of mitigate the blow on stuff like that. Pierce, anything else you want to add to this intro to collections and things like that?
Pay your bills. If you can.
Astutely said by a young, brilliant attorney. All right. Well, that's it for us for today. We'll see you next time with another video such as this. And I think Pierce is going to join me for the next video. So just know that here at Hildebrand Law Firm, we're here to protect your today and your future. Thank you.